Good afternoon. I'm Tim Borchers, and welcome to our seminar sponsored by our firm, Borchers Casano Trust Law. Today, we're doing the second in our series of post-election webinars on the subject of estate taxes, especially first in the case of estates that are considered modest these days, 2 to 10 million. And then today, we're discussing specific strategies for estates of 10 million and up, where there's likely to be a federal estate tax liability. If you have questions, please put them into the chat. Hopefully you can navigate your way to do that, and we'll look for those questions later in the program. I won't be taking them live. We'll just be reading them and replying at that point. So without further ado, let's get started. So here we are, post-election impact on those larger estates. This will be recorded and will be posted. Usually it's our YouTube channel, and I believe all attendees will get a reminder that that's happened. And so if you really want to know all my credentials, you can check our website, or I do have a few credentials, fortunately for you. Disclaimer today, obviously nothing here should be taken as legal advice. You need to have private consults for that purpose with us, certainly, or any other qualified attorneys that will help you out. I'm also making an assumption here, and I guess it's a disclaimer of sorts, that your objective is to try to leave as much wealth to your heirs as possible. However, I want you to challenge that assumption and be sure that there's a good reason for leaving wealth to your heirs. And of course, that's what good estate planning is all about, is trying to focus and to make the estate plan as useful as possible to improve the lives of those that you're leaving it to, or the community that you wish to serve. So what is the impact of the all-Republican federal government now on estate tax planning in this environment? So the first thing is there's probably going to be an extension. That's what all the pundits and also many politicians are talking about, an extension of the act from 2017 in the first Trump administration, in which the estate tax exemption on the federal level was doubled. It was doubled along with a lot of other income tax revisions. There's also other locally important income tax items that can be factored into your planning. Probably the most important one in Massachusetts is the so-called millionaire's tax. So the effect in 2018, when the law went into effect, was that the federal exemption went to $11.2 million for individuals and $22.4 million for couples, provided that the surviving spouse didn't remarry. The surviving spouse would be able to use the deceased spouse's exemption. And by the way, that doesn't work in Massachusetts. We can't piggyback the exemptions here, as we'll learn as we go along. Now, these numbers indexed for inflation, as of 2025, the new number will be 13.9 million for individuals and 27.8 million for married couples. And unless it's extended, however, be aware that as of the end of next year, the 31st of December, the doubling would go away. We would revert to roughly a $7 million exemption for individuals and only $14 million for couples. Now, these are large numbers for the vast majority of Americans, but they are very real numbers for a large part of the population and a large number of our clients. So that's why we are concerned here today. Now, I want to focus then on, for just a second, what's this about 10 million and up? I mean, these exemptions are higher than the 10 million by far. If you're an individual and the rate cuts back to 7 million and you have 10 million, well, that's obvious then that you're 3 million over and there will be an estate tax on your estate. But we're not talking yet about the exemption cutting in half. So we still have a $14 million exemption for the individuals, 28 for couples. what's this about $10 million being relevant? Well, it's all because of the growth in your assets. If you have $10 million today, I venture to say you're not big spenders. And if you have more than $10 million, you're not going to be spending all of that money. In fact, what happens usually is that we continue to see growth. And so your 10 million at 5% will double in 15 years. It'll double in only 10 years at 7%. And so we are talking about where your estate is headed. Now, if you're 99 years old, God bless you if you're on this video with us, this webinar, great. Maybe we don't have to be quite as worried, but I venture to guess most of you will still see some growth in your estate. What is the impact for planning in Massachusetts? So there's no direct impact on the federal government with regard to Massachusetts estate tax. There are a few states like Connecticut that does match up with the federal exemption. So in Connecticut, they could be losing a large exemption, cutting in half if the law changes and reverts back. But other states have just pegged their own independent numbers, like Maine, New York, Rhode Island, Vermont. And there's 12 states around the country that have estate taxes, and there's another half a dozen or so that have inheritance taxes. Most of the southern states don't have taxes. But anyway, in Massachusetts, there's no direct impact. If you want to know more about the tax situation in the northeastern states, you can find that on our website. If you just search for the Northeast Estate Planning Guide, which we will update every year, including in January. We have to have that updated. All right, so just a quick background on Massachusetts. Just as a reminder, some of you may not know that the exemption was doubled to $2 million in 2023, retroactive to the beginning of 2023. It had been only $1 million, which had put us as the worst in the country. We are now third worst in the country, but I'll take it. Next, there's no portability, as I said earlier, so either you use or lose that exemption or you protect the exemption. So we like to protect the exemption when we have the opportunity with married couples, especially. It's easy to do some protection. So we can often double the exemption by way of that protection from 2 million to 4 million for married couples. There's also no indexing for inflation in Massachusetts, so we're stuck with 2 million until the legislature gets around to changing, which the last time took about 16 years. Massachusetts has no gift tax, and it is not at this time clawing back large gifts into the taxable estate. But there's a caveat on that. They're not going to be clawed back provided that when you die, you're worth less than $2 million as an individual or 4 million as a couple using trusts. I know I'm talking fast here, but I want you to get the big picture, which is that it takes some careful planning still to make the best use of these exemptions. And a next point is not to be underemphasized. Massachusetts has now codified the exemption of out-of-state real estate. So that actually turns out to be a good strategy. If you have the ability to invest out of state in real estate, that will have the effect of lowering your Massachusetts estate tax liability. And then finally, Massachusetts got rid of the dreaded cliff for calculating the tax. One of the tax returns recently that we did, just being over the exemption amount by 100 grand increased their estate tax liability by 200 grand. There really wasn't a lot of logic to that, but yet that's the law, or it was the law. Now we've got rid of the cliff. So in other words, once you exceed the exemption, you're just going to start paying taxes at that point. You don't fall back down to $0 practically the way it used to be. All right, so what is your federal safety zone? If the state safety zone is only 2 million or 4 million as a couple using trusts, what's your federal safety zone? So in 2025, if you're single, if your estate is between 2 and 7 million, you can be reasonably confident your estate isn't going to be taxed. You could argue up to 14 million, because what's the likelihood that the estate tax exemption is going to roll back to the beginning of the year. It could happen. It could be retroactive if the legislature got really proactive on this. Prior to the election, we weren't sure. We were saying, well, maybe the the popular vote is going to go to Harris, in which case maybe we would have been stuck with a $7 million exemption. But in any event, for you as a single person, if you're up to $7 million, we can just about guarantee you're not going to be subject to a federal estate tax and in 2025. And the Massachusetts tax on that $7 million estate would be approximately 10% of the amount over $2 million. So you'd have a $7 million estate minus the $2 million exemption, $5 million subject to a 10% tax, or about $500,000 that your heirs will write a check for. If you're married and you're between 2 and 14 million, again, very unlikely that you're going to have to pay any federal tax. I mean, I think we should say it's as close to zero a probability that you'd have to pay any federal tax as possible. But there will be Massachusetts tax. You'll hit the top Massachusetts rate at about $9 million in assets. So if you were in a $14 million tax bracket for estate tax purposes, then you'd certainly be in that 16% range. So to make the math easy, just use 15% to rough out where you are in that. And again, if you have trust planning already in place or can do that with us, then you may be able to increase your exemption from 2 million to 4 million. If that was the case and you had a $14 million estate, you protected 14 million, that would leave 10 million exposed at a 15% tax rate. You'd be talking about $1.5 million. So $1.5 million tax liability for that couple that has $14 million and has done basic estate planning. But how can we improve on that? Well, if you're in the federal safety zone, you still definitely need to be doing trusts. You need to do revocable trusts and irrevocable trusts if you're really going to get aggressive. If you really mean it, that you really want to pass as much wealth as possible to do more good in the next generations and protect it while you're alive, while you're at it, then you really got to get serious with using these tools. The revocable trust tool, I'm not going to go into how that all works, but that's been working for married couples for decades now. So you at least have to have that. If you're single, revocable trust is good for taking care of your assets in your old age and avoiding probate. Irrevocable trusts are really what you need then to consider for their value in further lowering the estate tax. So we're going to give you a few examples today on how to implement some irrevocable trust ideas. The second thing you should do while you're staying vigilant here is prepare to implement more advanced strategies if your estate increases or if the laws become less favorable. So if we do have a cut in half of the exemption by 2026, you really need to be prepared to implement more advanced techniques. Stay vigilant. Estates double at 5% annual growth every 15 years, as I said earlier, every 10 years at 7%. And you're in retirement maybe or soon, thinking that you will be, and you're thinking, well, I'm not going to be earning that much money. I'm going to be more conservative in my investments. But you're also going to be spending less. You might have long-term care costs, but controlling for all of that, you're still going to increase in wealth. I don't think there's been a client in the last 500 of mine that have gone down in wealth during their retirement. It's just, it's not what you think it's going to be. You are going to continue to appreciate. Pay attention to the tax laws, number 4. Number 5, keep your appointments. If you're on our trust support program, which is great to keep you current, or otherwise review your plan with us if you're not on the program. Massachusetts, we've just went over some of these rules, but let's skip down to the bottom bullet items here. The last 2 bullets are life insurance can be exempt and trusts and LLCs work. So you're subject to Massachusetts estate tax. Your estate may be growing enough to be federal, but right now, what can you do just for Massachusetts purposes? What can you do to be more sophisticated than just the revocable trusts? Definitely life insurance. Use it as an investment, not just to replace your income. Life insurance can be exempt from your estate tax if it's held in an irrevocable trust. The trusts and LLCs, so limited liability companies, we're actually going to give you a concrete example on in a few minutes. So I won't go into that, but I think those may be in your future. You have to justify the life insurance investment. If that doesn't work for you for one reason or another, then definitely looking at limited liability companies to hold assets, and I'll show you how that helps you out in the end. And then trusts, irrevocable trusts used for gifting, also that I'm about to explain in more detail. So let's imagine for a moment a $6 million estate in Massachusetts for a single person. They're well over the $2 million tax break that their estate will get. There's nothing you can do, right? You're $4 million over. Not so fast. So Massachusetts has no gift tax and is not at this time clawing back the large gifts into the taxable estate, provided that by the time they die, they're under the exemption amount. So it's very profitable for that individual to fund irrevocable gift, or what I call gift and grow trusts. So gifting and growing, meaning that we can put large gifts into that trust. Somebody says, I've got cancer, I'm told I have 3 months to live. They could move from their $6 million, they could move $4 million immediately into an irrevocable gift trust and die, unfortunately, 3 months later with an estate below $2 million. There's no clawback, there's no estate tax due to the state of Massachusetts, and they've just saved $400,000 for their heirs. So clearly that's going to be a strategy to consider. Suppose they don't have terminal cancer and they live another 20 years. Well, that same $4 million gift, imagine that going into an irrevocable trust. Maybe they wouldn't do it all at once, but that irrevocable trust can actually be pretty flexible, and I'll be talking about that in a minute, how that could still potentially help this individual who's trying to lower his taxes. Even though he's given it away, it's possible that it could still be used to help that individual for the rest of his life. Owning real estate in another state as an investment or second home. And then the life insurance being tax-free by investing. All the premiums that are paid in are gift tax-free if it's structured correctly. And then all the proceeds are estate and income tax-free. So you might put in, let's say, $300,000 into a life insurance policy. Your heirs get $500,000. That's not a great return on your money, but the $200,000 of additional growth over above your premiums is all income tax-free when it's received, and the $500,000 is estate tax-free. And if you're in a 10 or 15% tax bracket, that's a decent savings. Clearly, there are times where $500,000 is not going to be enough to make the impact, so we're going to want clients to get quotes on even larger sums of life insurance money, life insurance policies. Now, that same $6 million for a married couple, number one, we want to protect the first $2 million exemption. By first, I mean the exemption that follows with the first spouse to die. So we want to protect that when the first spouse dies with a protection plan. So that's basic with planning with our firm is we've called it a protection plan for a few years now, but basically it's a revocable trust with a credit shelter or bypass or a family trust. All those terms have been used over the years. Right now we call it a family trust. So if you have a revocable trust, you're married, you have a revocable trust, and there's a section called a family trust, you already have this. If you have the family trust, you're all set to shelter up to $2 million at the first death. If you're at a $6 million estate level, and we can shelter $2 million there, the savings will add up considerably. Using the irrevocable gift and grow spousal or inheritance trusts, gifts of money, securities, businesses, or real estate, you could give up to $2 million so that when you die, we have the ability, even if you're over a $2 million estate when you die, if you haven't given away more than $2 million, that makes it easy to file the tax return, and we can clearly predict savings there. As you can tell, it immediately gets complicated, so we need to always look at the numbers and just how we're going to structure. And consider a second-to-die policy, which means it doesn't pay out until the second spouse dies. And finally, again, out-of-state real estate not being taxable. If you have a choice of where to get a second home, that could potentially influence whether you buy in the Berkshires or in New Hampshire, for example. Other things that you can do to reduce the size of your estate. Very often, I did this with my own parents. I said, just spend your IRAs or even just cash them in before you die. You pay the tax. You're in a lower tax bracket than your kids, mom and dad. Please just cash in your IRAs. You pay the tax on it, and we don't care whether we inherit your IRAs or not. But other ways to reduce your estate, besides from just cashing them in, is you can do Roth conversions. These are worth studying. There's lots of rules of thumb out there. If you're in a higher than a 25% tax bracket, some people think it's not worth it. I think you have to run the numbers. But what the whole point of it is that you're paying the income tax. By paying income tax, you're reducing the size of your estate. You don't want to pay tax, but it's either you pay the tax or your kids do. And then for the rest of your years, your Roth IRA will continue to grow. You do not have to take any distributions. There's no RMD requirement. And then following your death, your children would generally have 10 years to withdraw the funds. They do have an RMD requirement during those 10 years, but it'll also be coming out income tax free, usually with a lump sum by the 10th year is the way that works out. So I love to illustrate those situations and show how that can be powerful for net savings for everybody. Take those irrevocable gift trusts that we're talking about creating, move them to New Hampshire. So here's another advantage of playing with the income tax law. We can actually save on state income tax by moving the trust to New Hampshire, where there's no state income tax on irrevocable trusts, as long as the trust is a separate taxpayer. And that often works out very nicely, especially with long-term capital gains, which are taxed at 5% in Massachusetts. There'd be a zero tax on it in New Hampshire. If you're subject to the millionaire's tax, then we can also avoid the additional 4% tax on the income that you would receive and have to report in Massachusetts. So taking that trust to New Hampshire, there's administrative cost to do that. So I think that you should have at least a $2 million sum to take north to New Hampshire for this purpose. More on the illustration of the Roth conversion is given to you here. The net bottom line of all of this is that even for a modest $200,000 conversion, we're saving at least another $50,000 or so between all of the benefits. By taking a $4 million trust earning 7% to the state of New Hampshire and avoiding the 9% possibly, including millionaire's tax, the savings there will add up also very nicely. So if we had a 7% return on the $4 million, we'd have $280,000 of income in 1 year. The tax on that in Massachusetts at 5% would be $14,000. So we're going to save that. there might be $5,000 of administrative costs for having the trust in New Hampshire, but you're still netting an $11,000 savings. If you're avoiding a 9% tax, then that same $280,000 at 9% income, there we have a savings of $25,000 minus the $5,000 service charges. Again, netting $20,000 of savings. Multiply that savings over many years, and you've got a tremendous way to, it's like putting that money in the bank every year and compounding it. All right. So giving those gifts in excess of the annual exclusion, in other words, the annual exclusion, what would have been federally taxable gifts, you can give those away without a care in Massachusetts following these rules. You don't care that they would be, quote, taxable gifts. They're more than your annual exclusion. The annual exclusion, many of you maybe haven't updated your mindset. That used to be 10,000 for a lot of years. Then they started indexing it. In 2024, it's been $18,000 you can give away without having to file a gift tax return. It's about to turn to 19,000 in 2025. But that's a nice rule to follow, giving away $19,000 either to individuals or to a trust. But what if you could give away an unlimited amount? You know, and you're again in the federal safe zone. There's not going to be any gift tax on what you give away. So you can give away millions, literally millions, into a trust, and you file a gift tax return, but there's no tax to pay because it's under your exclusion, the lifetime exclusion, which is now the 14 million. You're under the federal lifetime exclusion, and you will not have to pay any federal gift tax, and it won't be clawed back into your Massachusetts estate. Again, provided that we can get your estate below 2 million at your death. Now that might be hard to achieve, but the next bullet point is very important. Even if we do have to bring your gifts back onto your estate tax return when you die, you're still better off, because what we've done is we've frozen the amount of the transfer. We've frozen it at whatever you gave away. So if it was $2 million, fine. But if by the time you died, that 2 million would have grown to 4 or 8 million through compounding, doubling every 10 or 15 years, as the case may be, for whatever your rate of return is. Imagine the savings on that by doing that gifting ahead of time. Even if they're clawed back, we only have to report the gifted amount of 2 million instead of the 8 million that it has grown to, excuse me. So it's definitely worth that inclusion. And also, if you have a federally taxable estate, imagine also being able to avoid the 40% federal tax. Next, let's look at, for the balance of our presentation, basically at 5 different major approaches to how estates that are beyond the federal safety zone will be treated. So what 5 techniques can we apply to improve the tax outcome for estates that are going to be beyond the federal safety zone? The first of these is those annual exclusions to gift and grow trusts. This might be done through disciplined annual gifting or potentially through lump sums. Freezing the transfer. So remember, the transfer tax system is all based on what does the government make you report. If when you die, your assets have greatly increased in value, then you have to report that greatly increased value amount. But if you've given it away ahead of time, especially if you've given it away in a trust where it's protected from your beneficiaries' debts and divorces and disabilities and destructive habits and so forth, then you have frozen the transfer at what someday might be a real bargain. You give it away in 2025 when it's worth, say, 5 million, and the tax on 5 million, even in a 40% tax bracket, is still a lot of money. It's $2 million. But if that same 5 million could have doubled or quadrupled over those years, then the tax savings is tremendous. So we're freezing the asset values to what they are at the time of transfer. So understand that's the value of doing lifetime transfer, is we're freezing the valuation for estate transfer purposes. So we can also do sales under the freezing category. If you have a business, for example, you could sell to a family member who's going to be taking over the business. You could sell at today's value by selling it to a trust for the benefit of that family member. So that's a sale to a trust technique, also highly worthwhile considering if you're a family business owner. The third technique is called discounting. And here, what we're doing is we're taking the present value of a future interest, and that's what we're transferring. So what's the present value of the future interest? So imagine that you promise to give somebody assets in 10 years from now, and you say, I'm going to give you $2 million in 10 years. Well, instead of waiting the 10 years to give them the $2 million, you give them an amount today that's going to grow to being worth 10 million. I'm sorry, 2 million in 10 years. So you get a discount in the amount of your exemption that you're using up based on the fact that you're giving away a future interest rather than a present transfer of the entire amount. And I'm going to illustrate that with you a little better in a couple of minutes. You also get a discount for deliberately creating a lack of marketability or a lack of control over assets by using limited liability companies. We'll be talking about that in this segment also. Nobody wants to buy your small share or minority share in a company. And you might say, well, what company? I'm going to show you how to create a family limited liability company that can hold any of your assets. And we also get a discount for lack of control. So that would be evident also as we go through. Life insurance leverage, I'm driving that point home again. So the purchase of death benefits that are much larger than the gift of the premiums is huge leverage there. And finally, charitable arrangements where you're giving the balance of the estate to charity, or you can do charitable remainder and charitable lead trusts. So let's dig into those in our remaining time. So the first thing, and I think this is one of the most powerful tools in our toolbox here. It's a gift and grow trust. And this can be done up to the $13.9 million in 2025. If we go over that amount, we're going to have to start paying gift tax. And these trusts can be for heirs or for spouses and heirs. So you can give that annual exclusion gift to children directly. That's nice. You can give them $19,000. They'll be very happy to receive that, I'm sure. Looks like a number is cut off there at the end of the second line. It should say you give to in 2025, $19,000 per person in 2025. But better yet, don't make it a direct give, make a gift using crummy powers. I was just talking with a trust support review client recently. They have used gift trusts for their children. One child was able to use money in the gift trust to help them with their home purchase. And the other one hasn't needed the financial help and has simply left the money in the trust. I think the parents just started this. They're only in their mid-60s. They put in to the one who hasn't had to spend it about $200,000. It's already worth $500,000. And that's all going to be exempt from estate tax at their death. They could tie it up. The child doesn't have to be given power to spend it. In fact, it's better if they're not, at least without consultation with an independent trustee. But it's the growth that we're after. really for the most leverage here that we're trying to get. So just a quick example in the middle of the screen there, we have, let's say there's 3 children and 7 grandchildren, so the 10 possible donees of the money. 10 times the $19,000 would be $190,000 worth of value that could be given every year. That could be cash, it could be securities, it could be a percentage interest in real estate. And if you're married, double that to $380,000. Now, there has been talk in the past, but mostly by certain Democratic members of Congress, about limiting how much we can give every year, but that has come nowhere near the floor of any House of Congress to vote on. I just don't think it's likely to happen anytime very soon. But could be another reason to get started, just in case they do change those rules later. So we're freezing the amount of the transfer and we're letting it grow. That's why I like the term gift and grow. And here's a diagram that helps illustrate it. On the top left, the donor puts money or real estate or other assets into the trust where it's allowed to gift and grow, number one. Number two, the assets produce income and capital gain, which is either reinvested, preferably, or distributed to beneficiaries. And it can be distributed to beneficiaries creatively. So in your old age, hence the man or woman with the walker there, in your old age, if you actually ended up needing some of that money, so to speak, your child can gift it back. They can pay some of your bills for you. We always talk about that as being a possibility. It's extremely rare that it's necessary, but nonetheless, it's good to know that our children would look after us, I suppose, is the way to think of it. It's even possible, by the way, to even add you back as a beneficiary of the trust if you are concerned about this. And then finally, the eventual inheritance. They receive the funds with the growth intact, and it's all going to be estate tax free. In a 40% tax bracket, 40 cents on every dollar is being saved by that technique. And those trusts, although they're irrevocable, they often, as my footnotes show you here, either we're going to make them a grantor trust, in which case you're going to still pay the income tax on the earnings inside that trust. That has the effect of further reducing your estate. Or you're going to let the trust be its own taxpayer, in which case it's an irrevocable non-grantor trust or ING trust. And the trust will either pay its own taxes. The danger there is that the trust will be thrown into the highest income tax bracket. And so we need to manage that tax liability. We can either make it taxable to the beneficiaries or, again, using that trust in a state where there's no state income tax will certainly help with that. Yeah, you don't want to be in the 37% tax bracket if you can help it, but that's on ordinary income. Most capital gain income is taxed at the federal level at 15% and only at the most 5% at least in this state. And if you take it to New Hampshire and invest there, we could potentially reduce that to 0 on the state side of it. So I love the gift and grow trust. It can be done. This illustrates it as though it's mostly for heirs, but it can also be done for a spouse. And the spousal trust variety, we call it a SLAT or a spousal lifetime access trust. These have become very, quote, popular recently because of the threat of the cutting in half of the federal exemption. And what that means is that for couples with estates larger than the exemption, likely at let's say 14 million for a couple, if the law expires or is allowed to expire, if they can give away the exemption amount now, even just giving it to their spouse, believe it or not, you can just give your exemption to your spouse. So if you had a couple right now with $28 million and they each gave the other one 14 million, so the husband gets a trust from wife for 14, the wife gets a trust from husband for 14, or from spouse for 14, then and then they cut the exemption in half, they still have 28 million, but they're locked in. They've locked in the savings at the 14 million exemption instead of being subjected to the only 7 million exemption that the law might change to. So that's why slats are very, quote, popular. Again, we can use them to draw from every year, or they can continue to grow. And whatever's left will go down to children. It also will escape taxation in the children's generation, because we're going to make these trusts generation skipping transfers. So we get even more wealth transferred to do more good later on. So the many types of trusts and other transactions to transfer present values of future interests, lack of marketability, discounts, and so forth. So let's go into some of these items now. One of the items that's in the law, we don't even have to make it up as we go along. It's provided right in the Internal Revenue Code, is what's called a Qualified Personal Residence Trust, or a QPERT. You can gift up to 2 residences to a QPERT or QPERTs. And what you're doing is you're giving away the present value of the future gift. So typically what the donors do is they take their primary residence and maybe a second home. If they're a couple, then they divide the property into tenants in common, so they each own only half of the property. And then they each create a qualified personal residence trust. They deed their half to the QPERT, and they provide a term of years where they're entitled to use the property like nothing ever happened. They continue to pay all the bills, etc. Let's say that you had a couple of 70-year-olds. They're in good health. Their life expectancy is to live until age 86. They might do a QPERT that gives them the right to use the property for 10 years, maybe 12 years. If they want to be a little bit more aggressive, they'll be 82 by that time. So one has to be careful, because if you don't survive the term, this technique doesn't work. But we love the QPERT for that purpose, for that reason. And I'll give you another illustration on this in just a minute. GRAT trusts are a little bit more complicated, but they can be used especially for business owners. We'll show you that in a minute as well. Lack of marketability, you're going to get that by owning things as tenants in common. Tenants in common can't break up their title to assets very easily. So there's a marketability discount for the fact that I just can't sell my partnership, or rather my tenancy in common interest, or even a partnership interest in a business very easily. I'm going to have to take a deep discount in order to get somebody to be my buyer, and the government lets us value the assets that way. They say, go ahead, take a discount for the fact that there's not much of a market for your interest. So that's what we get out of the tenancy in common. Fractional interest in a family LLC. So a family LLC is one in which there's tight restrictions on transfers. So unlike a business-oriented LLC where you may want to bring in partners, partners will come and go, we want to restrict it, again, so we can get a discount for the restrictions. And those restrictions are found in the requirement, for example, that you have unanimous approval of any sale of the underlying assets, or you have to have 95% of the owners agree to a sale, and you only initially retain 94%. So you need the others to vote with you. We're going to get a discount. What does that mean? When you die, the government says it's worth less. So we pay less tax on that asset as a result. Next, we can create non-voting and voting shares. The non-voting shares get a deeper discount on an S Corp, and common shares get a discount on C Corps. And in order to do all this, you need to do an appraisal of whatever the underlying asset is. let's skip over that. All right. So, and again, don't count out the value of life insurance policies held inside of an ILET. An ILET is the Irrevocable Life Insurance Trust. This technique's been around for decades. When my father died, I was looking through his papers and I found my grandfather's ILET from 1963. So it's tried and true technique. Here, your disciplined payments of premiums through the trust and good record keeping mean that whatever you're putting in every year buys life insurance. You're gifting it to the trust. The trust buys life insurance every year, pays the premium every year. And the death benefit is all out of your estate because you already gave it away. There's no further transfer when you die. The transfer occurred every year as you put the money in. And those premiums, for example, let's say you had 4 beneficiaries of your ILET, and you're allowed to put in $19,000 to them each year. That's $76,000 of premium that you could be packing that trust with, or maybe making a gift of cash to the trust, $76,000 a year. And that can buy quite a bit of life insurance. So all of that growth of the equity, the death benefit is income tax free. You can still borrow against the policy. And then second to die policies are even better investments when you're married. And then giving to charity can solve the estate tax problem a different way. Just give the balance of the estate over the exemption. We've had clients do this, and they say, it's good enough if my kids receive X million. Anything above that, it's just simply going to go to charity. What a simple way to eliminate tax liability. You'd rather pay it to the charity than to the government. That's understandable. But you can also provide yourself with a lifetime income and the remainder to charity. That also has the effect of getting that trust amount out of your estate. That's known as a charitable remainder because the charity gets what's left when you pass. You can reserve that for yourself, or when you die, you could say, I'm giving my children a charitable trust for life. And that's also a cool technique. So, you die, your kids have at least 30-year life expectancy. When you die, they could get 30 years of income off of that, and the balance goes to charity, and your estate will get a write-off for the amount of the present value of that gift at the time of your death. Complicated, maybe. To some, however, it's just what we do. So it's really not too bad. Now that we've done this many times. All right, let's go on to a case study. And this is where we'll wrap up. So Joe and Jane happen to have a $17 million estate. They own a vacation home worth $2 million. That will be an heirloom. So translate that to mean they don't care whether they pass it to their children necessarily ahead of their death or after, because we know it's going to be kept in the family for a bit. They're also less concerned about what some of you may know of as a step up in tax basis, which means that if you still own the home at your death, that it'll get adjusted. The tax basis will get adjusted to the date of death value. So you don't get that if you give it away ahead of time, but they don't care because nobody's going to be paying capital gains tax on it. They're not going to be selling the home. They're going to be keeping it in the family. They are also stock market investors, and they own a small business and real estate, all of which historically have produced returns of 7% annually. And we're going to consider that to be about 5% after tax. So before tax, about 7%. Jane, 66, is hopeful that they can do some real good with what they leave to their children and communities. She wants security for her 3 children, 7 grandchildren. Joe, 68, expects the business to continue to do well, though he has no illusions of a dot-com miracle. He agrees with Jane about the future and favors a charitable contribution. And then their financial advisors predict an estate of at least $35 million and as high as $50 million by their life expectancy, with assets continuing to grow And they'll probably grow at least twice the rate of inflation, which has an impact, as you'll see, on the estate tax calculations. All right, so let's take a couple of these items and how we might respond to them. So first of all, let's understand, what does it mean to have 17 million? So given that they're married, 17 million if they die tomorrow means that they're not going to presently have any federal estate tax to pay. But we're hoping they don't die tomorrow. And if their estate grows at, let's say, 5% after tax, and inflation stays at the historic level of 2%, then around about 2040, they're going to cross the line where their 17 million has grown beyond the federal exemption at current levels. So remember, the current level of exemption is 14 million each. That's 28 million. The federal estate tax is indexed for inflation, so that's historically 2%. So by 2040, their estate growing at 5% will overtake the federal exemption. So 17 million today, they can't sit on their laurels and say we're safe. They have to plan as though their estate is going to increase in value, as I've said over and over. In 2040, they'll only be 83 and 81, which today is still less than life expectancy for people that have made it to their ages. And they're going to begin to incur that estate tax at 40%. The longer they live, the worse the impact will be. So by my estimates, by age 88 and 86, their federal tax liability would be $1.7 million at that time. If the estate tax exemption cuts in half, then they're already taxable, aren't they? Because if it cuts in half, then they only get 7 each. That's 14 total, but they're worth 17 million. So today that would result in a 1.08 million federal tax if they died. And by the way, if they die in Massachusetts, the tax liability won't be any higher because Massachusetts tax will eat up most of that 1 million, which becomes a deduction against the federal tax. So no matter whether they live here or in another state, their tax on this size of a state would be approximately the same. People overlook that. They say, I don't want to die in Massachusetts. Well, if you have a large estate and you're paying federal tax, the Massachusetts tax isn't necessarily going to make it any worse because you're already paying a lot federally that you get a deduction on against the state amount paid. All right, so this was a good problem to have. They have this 17 million. What this also tells us is that they do have a large Massachusetts estate tax. So if they did die tomorrow and they're in a 16% tax bracket, then if they've got exposure of at least 15 million, if they only have a $2 million exemption, they haven't done good planning. 15, they've got about a $2.25 million estate tax payable to the state of Massachusetts. So I think they need to do some serious planning here at this time. Next item from our fact pattern. Jane's hopeful they can do some real good with what they leave to their children. She especially wants security for the 3 children and 7 grandchildren. So one thing they could definitely consider doing is putting their effort into wealth transfers now. So this whole gift and grow idea, together they can give the 10 exemptions to their 3 kids, 7 grandkids at $19,000 a year. They could give $380,000 per year for the foreseeable future. That may get bumped up with adjustments in the annual exclusion. But we're going to illustrate this as though the 380 never changes. Let's say they do that for 20 years. Now remember, they have 17 million to work with, and their assets are growing every year. So if they actually had the discipline and the wherewithal to do this at that rate, they could give away $7.6 million over the 20 years. But with growth on those amounts, and we've done the calculation with growth on the first 380, growth on the second 380, growth on the third 380, again at 5% after tax, Those gifts would total as much as $15 million, 15,578. That amount is totally out of their estate, and the savings in federal estate tax alone would be $6,231,000. So the gifting is extremely powerful. And if you think of that diagram where the money goes in, it grows, it's there to be used potentially for children, but it also could, if we needed it, be gifted back to mom and dad. So to continue the fact pattern, now after the gifting, even though they've given away 7.6 million, by their life expectancy, they'll still have another 29 million or so that they've got to deal with. And that also may incur federal estate tax. So they might decide, rather than waiting to give that money away annually, they do a large gift up front. They could do the slats, one to each other, or more likely with 17 million, I would probably have one of them give away 13 or 14 million dollars in trust to the other spouse, and the other spouse not make any gift at all. So very often I'm telling couples, yeah, you could each do a slat, but the numbers actually work out better if only one of you does the slat and use up your entire exemption of, or as much of it as you can afford to do, or find, you don't want to liquidate an IRA, for example, to pay a slat or make a gift, because you're going to lose if you do that. You're going to pay income tax. Yeah, so you have to have the right lineup of assets to do this. But this gifting, very effective. Joe expects his business to do well. He could use a GRAT. Now, GRATs, like I said, are somewhat complicated. They're not illustrating really well right now with higher interest rates. But basically what you're doing is you're getting leverage here on, you put money in, it's called a grantor retained annuity trust. The annuity is what the grantor, you, keep as a payment every year. So you keep an annuity that's based around the minimum rates allowed by the IRS, which right now would be 4.4%. You keep a 4.4% return while what you put into the trust is growing at whatever your company is growing at. If you got a really profitable company, it might be growing, let's say, at 10%. You get the arbitrage of the benefit of the 10% growth in what you've given away while you keep a 4%. Why are you keeping anything? What's the whole point of that? The point is that you may need to still have some support from the company and some revenue from the company, but you're also getting this discount by the fact that your rate of return is less. Now we're coming to the end of our hour here. I want this couple also to consider that QPERT, like I mentioned earlier, and I want them to consider charitable giving, to really bring down the value of the estate. I want them to consider the family limited liability company. I would say next to gifting and the ILIT for life insurance, I would say the family limited liability has got to be the third leg of your stool for further discounting of assets. So here we've had clients recently get discounts of 40%. It just happens to be the same as the federal estate tax rate. That's purely coincidental. A 40% discount. So you can, by creating this, it might appear to be artificial, but it has a legitimate business purpose. It can make loans. It can involve children in family wealth decision making. It can be investing in real estate or even family business assets. So we can apply these discounts. So when you die, you save a lot, or if you give it away while you're alive, you're giving away something at a reduced value compared to its true market value. I've had to talk really fast, haven't I, to get through all of this material, and I apologize for that, but I kind of want to give you the fire hose approach to how many great ideas there are to save on the estate taxes. And these tools are all available to anybody who wants to make the time to do it with us. I would say if you have a $10 million estate and you've never done any planning with us, I can virtually guarantee at least $1 million of savings. So let's talk about that if you haven't done so with us. And refer your friends to this video as well who may be in a similar bucket. I'm going to ask my technical aides here to get me back to the chat box, or maybe that's right over here, and I can even do it all by my lonesome. But what we should do is to see if there's any questions, and then wrap up so I don't keep you too much longer. So one question that has appeared in the box is, I'm 60 and I have an $11 million estate. When should I get serious about federal estate tax that will hit me? Well, fortunately, it's not going to hit you. It's going to hit the people who come after you. So if you want to, you can just make them pay all the tax in the world. But if you really want to save them some tax and pass more wealth and let them do even better, more good with it, now's the perfect time to think about that. Because if you're 60 and in average health, your life expectancy is probably at least 25 years at this point. And so what I'd say is your 11 million could very well turn into 30 million. You'll be well beyond the federal estate tax exemption. And so you need to get serious about it at this time. Let's see if there's anything else in here. Anybody else have a question? All right. Well, we are at the end of the hour, so I hate to keep you any longer. I really want to thank you, though, for spending time with me today. And again, I apologize for the rapid pace, but come and talk to me, and we'll see if we can improve on your estate plan. Thank you very much for being with us. Bye now.